Okay, sir, we are live now. Assalamu alaikum, everyone. Myself, Mohammad Ammar Zulfiqar Mirza, Secretary Media, LSC, Mail Site. Today, we have with us Sir Malik Huzaifa Saleem. He is currently advocate in Islamabad District Courts, and like us, as we are doing our bachelors from Islamic University, he is a graduate of International Islamic University back in 2021. He is a highly experienced and polished mooter who took part in multiple national and international moot competitions. And during his academic life, such as annual law, Pakistan Law College annual moot competition, Jessup International Moot competition, and also he appeared as a judge in the Intra-Faculty Moot competition that was held in the 2022 tenure. Also, he is a former intern at the Ministry of Law and Justice. Thank you, sir, for having being with us today. Um, our topic today is for the art of mooting. It's a very important topic as our organization is going to organize a moot competition in few days. I guess at the end of December. So pretty much there is a strength who wants to know what actually a moot competition is. So anything in the start, and you want to say? After that, we'll move on to the questions, sir.
Amar, thank you for this great introduction. It is always pleasure to be with you people, and thanks to this platform as well. Law Student Council has been a great council in our university since the time of my studies. I have been working around the corner with this council, and you people are doing a wonderful job. Thank you very much. Thank you again, Amar. Thank you, Shahid. Thank you, the president of the society as well. Okay, ladies and gentlemen, the first thing that Ammar said, I don't think I deserve this great introduction.
No.
Yet I believe that being a law pupil of law, the most important thing is that you have a strength at your hand that you can present in the court of law. The most pertinent thing here is that you cannot appear in the court of law unless you have a grip or a command on the legal facts, on the facts of the case, on the legal laws, and all other treaties, all other laws that are relevant to that question as well. So, as far as the art of mooting is concerned, which is the topic of today, and on which I am giving this opportunity to shed light, I would like to say that basically it is an oral presentation of the issue that is given to you people. When an issue is given to you people, initially a problem is drafted and that is forwarded to you people. You people have to study it thoroughly. After you start thoroughly, you what you do is you skim basically you skim the whole problem. After that, you consider that what are the issues involved, what are the things that are most relevant, what are the things that need proponent addressal, and we will shed light on these as well. So the first important thing I would like to add, Ammar, is that uh, the mooting gives the closest experience to a student. Like when we are studying in the universities, in law colleges, basically what we are less into is the art of mooting. However, ladies and gentlemen, I encourage you people to please participate in the moot court competitions, because it will polish your skills. It will enable you. It will maximize your abilities. Ladies and gentlemen, believe you me, it has helped me a lot. It has helped me a lot when I went it, and when I went in the district courts of Islamabad. It helped me a lot how to appear in the court of law, how to prepare the cases, how I have to take the strength, how I have to ignore what is not presentable in the court, because when you take your strength, it enables you, right? So if you are taking all the facts of the case, sometimes few facts of the case are against you. So when you will involve yourself in the mooting, basically mooting is something that has standardized evidence, right? You do not have to claim something that this is not part of the evidence. It is written and it is proved fact. So you do not have to challenge the facts basically in the mooting. So Ammar, I would like to add here something that most of the people of our generation do not understand, which I say the difference between moots and mock trials. So basically, moots are the the given questions that are presented to you by your platform, like Law Student Council is going to organize a competition with a collaboration with a law college. So what you people will do, you people will give a mood problem. Certainly, I guess it is out, right, Ammar? The mood problem is out. Okay, mood problem is out for you people. Now what you have to do is that the evidence has been tested. Like, be very clear, in the moot court competition the evidence has already been tested, and you do not have to deny what is already mentioned in the fact book, what is already mentioned in the problem. As far as the MOOC trials are concerned, there is a huge difference that first you have to test the evidence. What you do is that you test the evidence, what is given to you people, you have to test. Like here we have very few platforms that encourage mock trials, while I'm of the view that we must have mock trials as well. And I believe that inshallah Law Student Council will organize the MOOC trials in the future as well. So the most important thing is that you have to test the level of the evidence in the mock trials. Second, you have to establish the case facts. Third, you have to present in the court of law. When you go to the moot problems, you directly have to present in the court of law what already has been proved. So what you do is that you study the given law, you study the given legislation directly touch the soul of the question. What you do, the most important thing, another thing that I would like to mention is that what students generally are mistaken about, that they just simply do not consider the important facts and important points in their problem, which are directly related to certain law. For instance, let us say something is directly related to Pakistan Penal Code, or something is directly related to an international treaty. It can be a Geneva Convention if it is a question of humanitarian law, etc. What people ignore is that they do not read the facts properly. They do not understand the facts properly. Ammar, what I would like to mention is that what our students must do is that they must get a strong command on the facts that are provided. After all, we judges are examining, the judges of the moot are examining the people that are appearing in front of them on the basis that they have a good knowledge of facts or not. If you are good at facts, you will be able to apply the law. You have ample time for that. And another thing, if when the last thing, then I will go for the questions. Ammar, please pardon me, I am taking the time. So when the moot problem is released, what you people have to do, ladies and gentlemen, first thing is to set the deadline. Deadlines are very important, and these needs to be met. If you are not able to met the deadlines in this mood generally, and in your life ordinarily, to say, you people would not be successful in your lives. Please set the deadlines, please be strict to them. After that, understand the problem. Ladies and gentlemen, understanding the problem is very, very important. When you are not able to understand, you cannot comprehend what is being asked, what are the questions at the end of the problem. So what I would like to add is that please skim, like we call it separating grain from the chef. Like, what you have to do is that you have to separate the material and immaterial facts. There are few things that person A was traveling from Rawalpindi to Islamabad in the, for instance, it is mentioned in the case in the given moot problem, and he adds something. For instance, if eating something is not directly related to the case, you have to ignore it. It is an immaterial fact. Easily to say that. And what next you have to do is that you have to conduct your research. When you will do a thorough research, you will be able to grasp what has been asked from you. After your research, you will be able to draft a memorial, but researching is a pertinent aspect. It is a prerequisite of a good moot. If you have not drafted a well-researched memorial, you will not be able to ascend in this competition. Next is the understanding of the scope. Basically, there are two things that are related to the scope of the question. One is you have to study the scope of the problem. Like, if jurisdiction is involved, which type of jurisdiction the problem is asking about. which is the court that refers to that jurisdiction. Is that court having the competent jurisdiction or not? You have to understand the scope of the issue as well. The scope of the issue will be related to for instance, let me say that the case is about contract act. Now you have to see that contract act is the basic law, basic substantial law that will apply to it, right? After all, the procedural law will be the civil procedure code, but the basic fundamental law will be the contract law. If you have not studied the contract act, how you will be able to comprehend, how you will be able to give your view, your opinion, because judges in the moot court competition are expecting what a legal opinion is, what the way you can assist them in solving that moot court problem. Later on, what if you have studied the moot problem completely, now you have started researching on the issue, what you can do is, first of all, you can look into the legislation. Legislation is very important. It is primary source. You have to see that where the legislation is available, right? We lawyers say that lawyer is not a person who has memorized the law. He knows where the law is, right? So where the law is very important. You people must be knowing that where certain provision is provided in certain law. Next, you have to study the treaties. If it is an international problem, if it is an international moot court competition, if an international dispute is involved, you have to give importance to the treaties as well. Third would be the commentaries of the local laws and international laws as well. And the fourth important thing will be judicial decisions. After you have done the research properly, you have to draft your memorial. After that, we will be discussing the other aspects as well. Up to you, Ammar, please. Thank you.
Thank you, sir. That was a brilliant explanation about a mood situation and a mood competition. Thank you for that. Well, moving on towards the question, sir. Sir, in 2 or 3 lines, for like many of the students that are appearing in the mood competition coming on, they are belonging from the first or second semester. For them, can you in just 2 or 3 lines explain what is a mood competition, like in simple words?
See, Ammar, first of all, I congratulate all the participants. It is like great pleasure to know that the students of first and second semester are going to appear. Like they are just nuisance boys and girls of law, and if they are going to appear, it is something that is quite encouraging. So, Ammar, as far as your question is concerned, as I already told you people, the moot is simply a stimulator of an original chord. What will be happening is that a problem will be presented to you people. You have to be on one side and the other side as well. You have to be the defendant as well, and you have to be on the other side as well. Now, the important thing is that you people must be knowing that if you are defendant, on what side you have to stand, and if you are claiming something, on what side you have to stand. And the next thing is that in the moot court competition, generally, when a problem is presented to the students, they have to do a research. After that, they have to draft a memorial. After drafting the memorial, after the people submit the memorial to the authorities, the memorial is skimmed by the law student council. After all, in the oral rounds, there would be certain oral rounds, initial oral rounds. I do not know what will be the procedure exactly by you people, but I will be telling you the general procedure that is followed internationally and nationally as well. So in the first oral rounds, preliminary rounds, students would be initially skimmed about their knowledge of facts. There would be judges. There can be a single judge. There can be a bench. There can be 2 or 3 judges as well. So they will be examining the student on the basis of the facts they are studying, on the basis of the law they are applying. On the basis of that, the judge will ask certain questions. So what the presenter, what the mooter has to do is that he has to or she has to present his connotation, his scheme of ideas as well, and he has to answer the questions of the judge as well. After that, the judge will decide that which team has performed in a better manner. I hope I am clear.
Yeah, right. So thank you, sir. So moving on towards the next question, it is as I've also participated in past mood competitions, so a basic question that I wanted to ask from my seniors was that when you guys are entering into a mood competition, what is going on in your mind? Like how, what are the tips and tricks to keep remain yourself calm, and how to make your argument strong enough in front of the judges?
Ammar, thank you very much. First of all, let me tell you that there is a verse. Iqbal Rahmatullah alayh said, "दो आलम से करती है बेगाना दिल को, अजब चीज है लज्जत आशनाई." So when you get that lazzat ashnai, when you get that knowledge, the knowledge aspect gives you confidence. So in the nutshell, I will say that you have to gain the knowledge, you have to develop an expertise. So let me tell you my experience. I and the Atif Siddiq were in the moot court competition at Pakistan College of Law. When our opponent team was appearing, we had rebuttals and sir rebuttals. So I got a chance of rebuttals. So a judge asked me that, okay, gentlemen, okay, consul, I want you to do a good rebuttal. So I did my best, what I could do. You would not believe that those questions were so crisp and so to the point that the other team was not even able to come in the sir rebuttals. What they did, okay, sir, we don't want to appear in the sir rebuttals. So it was very evident that we have won. So what you have to do is that you have to understand that they are judges, like they are common people. They are not going to be some Dracula, or they are going to eat you like that. There is nothing like that. They are people from you. They have studied the law. They have been student in their past career as well. What is important is that be composed. Be composed. As you asked that how to develop the confidence, what I would recommend is the practice. So, ladies and gentlemen, the practice is the key. When you start practicing, you develop something. You develop an intrinsic ability to appear in front of the court that enables you to stand in front of the tide or stand in front of the grill of the judges. So, best of luck.
Well, thank you, sir. I hope they are noting these points down, because not only in mood competitions in near future when they will be practicing in the courts, these are some key points to be noted. Moving on towards the next question, sir. Sir, you did explain what how to analyze a mood problem, but for the beginners, what are you some suggestions that how when a question related to a mood comes in front of them, what are some key points, few key points for them to keep in mind before working on the memorial?
All right. Ammar, first of all, for the starters, those who are new into the game, right? I would like to say that please do not demotivate yourselves on the grounds that I have not studied international law, I have not studied this very law, I have not studied the Pakistan Penal Code, the Criminal Procedure Code, the CPCs, and the Contract Act. Please, this cannot be a denial. What is this basically? In psychology, we say that when a person has been flunked, when you are not able to drive yourself, when there is no force that is appearing in front of you people that has been arisen from inside, then what you do is that you sit down and say, yes, I cannot do this, I cannot stand against the tide. Please do not do this. What you have to do is that initially grasp the facts, and please discuss with your peers, with your teachers as well. No one has stopped you. Please discuss it with your peers, with your teachers, with your mentors, with your seniors as well, that this is the problem and this is my take on this. I can relate this to this very law, this very provision, this very section. Then you will be able to understand. For instance, I would like to say then when I was appearing in a competition, moot court competition that was online as well. So what basically happened that I was not able to understand few provisions of law, although I was in the senior semester as well. But please, it is quite acceptable. It is quite acceptable. If you do not know certain thing in the law, it is acceptable. But denial of the appearance is not acceptable. Denial of presenting in the court of law is no excuse, please. So what I will recommend, Ammar, is that for the beginners, uh, please study the law thoroughly. Please study the involved commentaries of the law. Please study international authors. That will enable you people to have confidence in yourself, and then you will be able to do the good research as well.
Right, right, sir. Thank you, sir. Now,
Yeah.
another step in the moot is the memorial. So, preparation of a memorial is like a basic step before going into the moot competition. So, sir, with your experience and with your knowledge, what are your suggestions and tips to the beginners? How should they prepare a memorial?
All right. Uh, well, Ammar, I will divide your question in two aspects: the importance of the memorial and the structure of memorial. So we will be holistically addressing both the sides, right? So first thing, the importance of the memorial. See, basically, Ammar, what happens is in the moot court competition, you have to draft a memorial that will be in front of the judges. So before I appear in front of a judge, my memorial will be there. If I have addressed the question properly, like when I was judging the moot court competition, when I used to see the memorial like this, I was able to understand that yes, this person has done some level of research. So this gentleman has got certain potential. Yes, I will not leave you. I will grill you, right? I will like to see that what is your potential. Shahir can easily quote that how I grilled him in an international in that IIUI moot court competition as well. So what is important is that the team that won in the competition was quite capable to stand the grill. It is not important that you people have to you people have to focus on the memorial and you do not have to present it properly. So please focus on the memorial, focus on its drafting, focus on your research, and focus on your presentation as well. Now its importance is quite undeniable. See, when a memorial comes in front of me, I will study, yes, okay, it is his prayer. And yes, and now I can see Shahir laughing as well. So, gentlemen, best of luck for your future endeavors as well. So, Ammar, I was talking about the thing that what you have to do is while drafting a memorial, you have to keep it in mind that this is your face in front of a judge. Like, see, if you have to appear, if I am appearing in this webinar, why you and I are presentable? Simply answer this. We are presentable because we think that our presentation matters a lot, right? So how can I deny the presentation of a memorial? When a judge is going to see that memorial, he is going to judge that this person is knowing the prospects, aspects, and ambit of the law. He is knowing the scope. He is able to comprehend the given questions. After that, the person will be coming in front of a judge. Okay, yes, you have written this, you have written this. So, counsel, please assist me on this matter as well. So, memorial is very important. Now, how to draft a memorial? Ladies and gentlemen, I will be giving you certain points. Quite that would not be too much, but few points. Please pardon me, Ammar. Okay, a few points. The first thing about the memorial is the front page. You have to write the front page on which there will be a title, there will be the number of the team, there will be the logo, etc., everything. Then there will be a table of content. Second thing will be table of content. Table of content will be having all the content that you have included in your memorial, right? Next will be the list of abbreviations. The third thing will be the list of abbreviations. You have to add the abbreviations. Please understand the difference between abbreviations and other things that are important in the law as well. So, if you will not be able to comprehend that, if you are not writing a proper abbreviation, that will get you on a fix. Okay? That is very important thing. The third thing is the list of the sources and authorities. What you have seen, what you have studied, what you have linked your idea to, what is the fundamental thing that the authority on which you have relied your argument will be in the list of the sources and the list of authorities. The next thing is the statement of relevant facts. What you have to do is that you have to read the given facts completely. Please do it at least 4 to 5 times. After that, what you have to do is that you have to skim out. I already told you that you have to separate the grain from the chaff. You have to separate the material and immaterial facts. So the material facts would be taken out, and simply a summary would be made. A statement of relevant facts would be drafted on the fifth aspect. After that, what you have to do is that the statement of the jurisdiction, that this court in front of which this council is appearing is competent enough and has a competent jurisdiction to give a decision on this very dispute. So this is the important thing. After that, the council will address the question presented, that these are the questions that I'm going to present, and they can divide the questions as well. If there are two councils, if there are two participants, if there are two candidates or three, they can divide on the basis of the organization that law student council will be guiding you people later on. After that, you have to add the summary of the pleadings. So summary of the pleadings, that what are the summaries of your pleadings in quite one or two paragraphs simply. What I see, Ammar, is that few students give the holistic opinion on their pleadings and the summary of pleadings as well. So what happens is there is a repetition. And believe me, ladies and gentlemen, Ammar, this repetition is very redundant to the judges. When I was judging, I simply looked at the summary. I was able to comprehend that, yes, this is the thing. So please do not exaggerate the summary of the pleadings. Secondly, please write all the pertinent pleadings in the summary as well. That if you are giving certain legislation, if you are referring to certain judgment, if you are referring to certain precedent, please mention it in one or two lines. After that, you have to give the pleadings. This is the point where you have to draft a complete pleadings on your question. For instance, let us say the question is about, do this court has a competent jurisdiction to look into this matter? Now the answer can be yes or no, and it has to be. For one party it has to be yes, and for other it has to be no. But you do not directly have to go for yes and no. You have to do is, in your pleadings, you have to mention that why this court is competent enough to take the cognizance on this matter. And in other instance, why this court is not competent enough to take the cognizance on the matter. If it is a criminal case, for instance, to say, in other cases as well, the same procedure will be followed. After that, you have to give the prayer. The prayer is what you seek from the judge. Simply, the prayer is what you want, what relief you expect from the judge as well. So the important thing here is that you have to mention in just 2 or 3 lines that you want this type of relief for your party, and the other party will be mentioning quite another aspect in the prayer. Of course, there is a separate prayer for both the parties, for both the applicants and both the respondents. So yes, Ammar, this was the general, you can call it the structure of the memorial.
Thank you, sir, for that. Before moving on towards how the research and other stuff for the memorial should be done, sir, I would like you to explain what is the difference between a national moot competition and international moot competition.
Okay. See, Ammar, firstly, there is no organizational difference. Simply, there is a structural difference. I call it a structural difference. You can call it organization difference as well, but let me explain why I call it a structural difference. In a national moot court competition, an organization, a college, a university, or any other institute will be providing students a platform to appear in a moot court competition that would be of a national cadre. What will be happening, that teams from different law colleges, from different prestigious law universities, from different legal institutes would be appearing, and they will be competing at a national level. The judges would be they can be experienced mooters, they can be experienced lawyers, advocates, solicitors, barristers, they can be former judges as well. So when we go to an international moot court competition, 2 things differ. First is basically structure. There will be national rounds and then international rounds. The teams that have qualified for the international rounds, in the national rounds, would only get an opportunity to appear in front of the judges in international rounds. So there are two types of round in international moot court competition. First, you have to appear in front in the national rounds. I remember in the Jessup moot court competition, I was sixth best oralist. In my time, it was online. It was my first experience. So I would like to add for you people that it is important and it is quite suggested and recommended from my side as well that if you want to be a good mooter, please start from the national moots. Do not directly jump into the international moots. So this is what I did. I jumped directly into international moots. I was not knowing the ABCD. Thanks to the Law Student Council, this is giving you a platform and an opportunity to learn. Believe me, I and my other colleagues were not having this type of opportunity. So thanks the legal system of Pakistan is growing in this great and splendid manner. And I hope that we people will be able to add the light in the certain aspects of law, inshallah. So Ammar, what is another difference is what when you qualify from national to international rounds. In international rounds, there is a diverse competition because international teams are appearing simply to say, like for me, when I was appearing against Germany, they had a certain spatial background, a certain spatial setup. So like they were creating a deterrence. Okay, so you Pakistanis are going to appear against us. So what I did, I was sitting like one of my participants was sitting in Islamabad, and I was sitting some certain 250 kilometers away. So we were texting each other. Yes, they are creating a good deterrence, but we have to do as well. And Ammar, let me mention that this is the part of record that we scored greater than that team, that German team. So it is not about your background. It is not about where you are. It is not about the setup you have. In international rounds, if it is an online competition, what will eventually matter is your grip on law. The other thing is that it has, of course, an international recognition. If you have appeared in Philip C. Jessup moot court competition, if you have appeared in John Pictet, there is an international recognition attached to it. So it matters a lot. You can glorify your CV as well. So yes, this is the initial difference I would like to mention.
Right, right, sir. Thank you, sir. Moving on, sir. Coming back towards the memorial and the process, sir, how a person, a beginner, should do the research for the memorial. As you explained, different points involved in the drafting of memorials. What research is not required, so the person is able to draft the memorial.
All right. See, Ammar, when the research is concerned, first I told you that you have to grasp the most pertinent thing of your problem is the fact. The most pertinent thing is the fact of the question. First of all, understand the facts. Please develop your instinct that this fact means this and this fact never means this. For one side, choose one side of your presentation, whether it be claimant, whether it be defendant. Please choose one side. After choosing the one side of your presentation, what you have to do is you have to grasp the facts, and it is quite natural that and in any given moot problem, one side would be having an edge on the other. So one side will be strong and other will be weak. So judges also understand this, that this side, this part of the question is already in the favor of opponents of the person who is appearing in front of a judge. So please do not consider yourself that I am answering a difficult question. I am answering the ardent aspect of law, so I will not be able to comprehend. Please do not get yourself into this dilemma. First of all, while doing research, understand the problem. It is very important. You cannot deny the aspects of the problem that are asked or that have been asked from you. So a judge will be having a preemptive mindset that yes, if this person is appearing in front of me, I at least consider that this person will answer these three or four major aspects of the question. So you people will only be able to understand these parts if you have understood the scope of the problem and the scope of the law that is involved. So the second thing is understanding the scope of law. So basically, what is the thing? Like, if you people have to answer about the jurisdiction of International Court of Justice, so it has been mentioned in ICJ statute. If you have to mention about the sources of international law, these are again mentioned. So you people must be knowing what is the scope, what is the scope of treaty, what is not the scope of treaty. For instance, I quite often refer about the problem of the Kashmir. I will highly recommend, please read an opinion in the Dawn that was published back in 2019. The name was binding resolutions, if my memory is giving my aid. So I would like, please, I will be recommending you, please read it. It is a wonderful explanation by Sir Ammar Bilal Sufi, and he has contended that this aspect is very pertinent to be presented in International Court of Justice when we are concerned about the matter of Kashmir. So what I want to mention is that while researching, you must be knowing that what is the scope of chapter 5 of the UN Charter, what is the scope of chapter 4, and what is the scope of chapter 6, under which chapter United Nations Security Council will be giving binding resolutions, and under which chapter it is not giving binding resolution. So there can be certain procedure about that as well, but it is not about our concern. Our concern is the scope. Our concern is the pertinence. You have, after the understanding of the problem, after the understanding of the given facts of the case, what you have to do is you have to basically center your arguments on the sections that are directly attracting that problem. You have to refer to those sections of law. If you are missing on them, you will get a fix. See, if a person is appearing and is contending that, see, your honor, your excellency, I want this is my claim, and he or she is not knowing the relevant proviso of law, how any judge can simply give him a good credit or give her a good credit? Of course, they will not. Third, the second aspect is to understand the articles of the Constitution, if it is involved. Understand the articles of international treaties if they are involved. You have to see that whether there is a redundant article, where there is whether there is a sub article that is going against my standing. So please focus on the given legislation. Read bare acts. It can be a good aspect of researching. You have to study the bare acts. You have to study why okay, what Shahir is asking. All right, Muhammad Sheed. I'm going to address this as well. Thank you. Okay. The next aspect is you have to refer to the you have what you have to refer is to refer to the bare acts. For instance, like, there is a difficulty when I was studying, when I was student, and quite now as well, we are not able to comprehend certain provisos of the legislation. For instance, if you read abatement, so abatement is given in the Pakistan Penal Code. So there are very different instances that this can be an abatement or this cannot be an abatement. So what you have to do is you have to be very crisp and very clear that yes, this is an abatement, this is an abatement, and then you have to study the commentary of the Pakistan Penal Code. You have to study the relevant books. You have to study the Kanun-e-Shahadat as well. You have to study the judgments as well, the precedents of the superior judiciary. After all, when I link the Ammar, your question with the aspect of the national moot court competitions, well, the thing would be quite same, but in a different manner. The method is the same, but manner is different. In an international moot court competition, we were focusing on international legislations, international bilateral unilateral treaties, international trilaterals, multilateral treaties, international non-governmental organization, BINGOs, INGOs, etc., United Nations, the provisions in the UN Charter. But when we are studying a problem of the scope of national law, we have to focus on the national statutes. Please, if you are appearing in a national moot court competition, and at the end of the problem, there will be mentioned that for this moot problem, laws of Pakistan would be applied in their very nature, in their very virtue, as per se, exactly to say. What you have to do, ladies and gentlemen, you have to study the laws of Pakistan, because if you are referring any international law, if you are referring a law from a neighboring country, that would not be of the binding nature to the court. So if you want to bind the court against your argument, you have to present a national legislation. So again, I told you that the method is the same. What you have to do is you have to research a bare act. For instance, the problem is about Pakistan Penal Code. Ammar, I'm not knowing the very nature of your problem. It is about penal code, it is about criminal law or civil legislation. I'm not knowing. What you have to do, I have not seen, unfortunately, I have not seen the problem yet. And you have not forwarded it to me right now. So what you people have to do is that you have to study the prospects of the national legislation. Let me give you my experience. When I was appearing in a case, it was the case of the National Police Foundation. We are the legal advisors of the National Police Foundation as well. When I appeared in front of a judge, what she said is, "See, consul, I have to call your DG." So she wanted to call DG in front of the court. She issued summons. So what is the problem for us? We, being the legal advisors of the National Police Foundation, have to make sure that DG has not to be called. Why he should not be called in front of the court? Because he is being the administrative in charge of the foundation. He is not knowing the intricacies that are involved in the legal questions. So what I mentioned in front of that honorable judge, I requested her to please call the director housing. She was not willing. She said, "No, consul, I will call your DG." I said, "No, your excellency, please call, your honor, please call the director housing, because he is here since last 15 years and he is knowing what are the factums, what are the intricacies that are involved, what are the basic things involved. If I was not able to understand the act of the NPF under which it is created, I was not knowing this." So please relate this aspect with your question, that if you people have to appear in front of a national court, you have to make sure that you are knowing the both the aspects of a legislation. A legislation can be in your favor, and if you have not comprehended it properly, it can be against you. If a judge has the strength and you are lacking that strength, this will create a huge dilemma for you while you will be appearing, that the judge will be asking you a question, that the consul, are you knowing this law is not applicable in this problem? What you people will be doing that at that point? So please understand the scope of the legislation, understand where it is applicable and where it is not. This will give you an important idea about the research as well. My
Right, sir.
apologies.
Yeah.
Please excuse me, Ammar. The last thing is the constitution. When we refer to the constitutional articles, what you have to do, if the nature is about constitution, like Shahid just mentioned, so constitutional law is a law of very premise. It's a fundamental law of the state. So you have to develop the grip on it. You have to develop under which law, under which provision Supreme Court has been established, under which provision High Court is established. What are the nature of the jurisdictions of the High Court? What are the natures of the jurisdiction of a Supreme Court? For instance, if I ask a mooter that, "Do you know that Supreme Court, what is your opinion? Can Supreme Court take a trial of a case in an ordinary circumstance?" And the counsel is not knowing this very fundamental thing, I will be knowing that he or she is not having a grip on this very fundamental legislation. And the questions can be very diverse. So what judges will be doing, they will be asking you some basic questions about the constitution, about its scope, what is its nature, what under which article Supreme Court is established, etc. So please please read these fundamental articles of the Constitution in very detail. Yes, Ammar, please.
Right, sir. Sir, the question is related to the question we are discussing right now. Can the international articles, for the sake of understanding, be used in the
In a
memorial?
national mood.
Yes, sir.
Well, Ammar, strictly to say, when you are appearing in a national court, please stick to national legislation. Yes, if you think that this is an aspect of such issue that there is no national legislation on it, it would not be a case in moot court problem. Of course, there would be certain national legislation. Or if you think that national legislation is available, but its proviso is lacking the aspect that you want to claim, then you can refer, but that will be a subsidiary reference. That will not be a primary reference. Rightly to say, please be strict to national laws.
Right, sir. Sir, moving on. Sir, what are the basic rules for a mooter should follow entering into a moot competition? The basic rules.
Ammar, see, you are a very smart guy. You are asking me the questions that I will be judging, right? So, okay, let me tell you. Let me tell you. What is your question? That what? Please.
Some basic rules which are required for a person to follow in the moot
Okay.
competition.
Okay. Yes. For instance, for a person like me, if a consul is appearing without a tie, it will be a worse impact for me. Like if a consul is going to argue with any co-judge, with any senior judge sitting besides me, with with me as well, this will not be something positive. I can deny it. I can say that, okay, please, it is let me pardon you on this aspect, but it will give negative understanding. It will give negative connotation to other judges as well. So please be composed, wear a clean suit, have a great presentation. Please have a clear smile on your face. Please do not appear that I am certain type of tycoon and I am appearing and I will get my aspect. You will get nothing. So please, what lawyer has to be? What lawyer has to be in the court, Ammar? I have experienced this. You have to be very knowledgeable. You have to be very disciplined. You have to be very mature on your arguments, and you have to be very accommodative to the judge. If the judge is stopping you from your argument, please stop. Do not try to complete your argument. Take it on the second instance. And this is the important thing. Yes, Ammar, please. Ammar, please, you are not audible to me. I cannot hear you. Okay.
Sorry. Moving on towards the final few questions. After that, we'll go towards the comment section and the questions asked by our viewers. Sir, at the end of a moot competition, what should a person who is entering into the moot competition and while he is leaving the moot competition, whatever the result is, what is the basic points he should take away with him while leaving a moot competition?
Well, Ammar, see, this moot court competition gives you a diverse experience of appearing in front of the court. See, when I was appearing in the national competitions and international competitions, for me, it was not an issue to appear in front of a district judge. So I can relate to my past experience. That is certain another aspect, although. Yet I would like to say that yes, some of my confidence was driven through this mooting aspect as well. So what I believe is that you people must take the notes that yes, this was my shortcoming, this was my denial of the aspect, this was my weakness, and this is the thing where I have to work to ensure that next time I will be able to be appearing in the front of certain other court or another moot court competition in very glorified manner, in very improved manner. So Ammar, what I believe is there is no end to this legal grooming. Everyone, we are just minor students of law. those who have the experience of 20 years, 30 years, I have heard them, I have witnessed to their claim that we are just pupils of law. What to say about ourselves? So it is a learning experience. Law is all about the stages. You have to move from one stage to another. Yes, it will be a learning experience for you, and please do not take it on heart. Please do not be demotivated. Yes, I have been grilled, or this judge has been wrong to me. There is no thing like personal grooming, personal grudge about you. There will no judge will be having a personal grudge. Yes, there can be an amusing aspect as well. There can be a tough judge as well. So you people know who was the tough judge. So I would not be mentioning these aspects, but I believe the judges who are strict are my favorite judges, because they give you an identity to stand alone. They give you a reason to appear in front of another judge. If you are able to present in front of a strict judge, it is quite easy for you to appear in front of a judge who is not that strict. So please do not idealize a certain type of a judges. Please do not idealize that I want this ideal condition. There will be no ideal condition in real court as well. So please do not expect any ideal condition. What you have to do is you have to present your best opinion about the law. You have to aid the judge. This is the basic fundamental aspect of the advocacy. It is primary skill that we are the officers of the court. We have to assist the judge. So please be assistive. Please be assistant of the judge. Yes, Ammar, please.
Thank you, sir, for
I
that.
hope I am clear.
Sir, I guess even for the beginners, they are clear enough what a mood competition really is and how should they be prepared for the upcoming mood competitions too. Sir, there was a question. I guess we'll move on towards the question now. By Unibur Rahman, that what while oral pleadings, what should be the tone, manner, and your body language? Um,
Well, Unibur Rahman asking this question, very fundamental and excellent. This is a wonderful question. Ammar, fundamental things about the appearance, about the oral proceedings. See, first of all, judge is not sir. Please do not address him like sir. Please, in your practice, your honor, your excellency. If there is a lady judge, your ladyship, your lordship. These are certain connotations that you attach to a judge. There is no word like sir in the court of law, right? Second important thing is that about the tone of the counsel. Please be very crisp, very clear, very vivid in your speaking. Like judge must be able to understand what this counsel is going to mention and what are the aspects of law he is going to clear in front of me. If you are murmuring, if you are not able to give your opinion, and please do not demotivate yourself if you are not having good communication skills. Please, this is just a language. ये अंग्रेजी जो है इसको सिर्फ प्लीज जबान समझो. ये जबान से बढ़ के कुछ नहीं है. आई एम सॉरी अमार, आई एम ट्रांससेंडिंग टू द नेशनल लैंग्वेज. As
no, no,
you
it is
people
it
already
is
mentioned,
it is required
yeah,
because for some
yeah,
people they understand in the national language better.
quite better. देखो, let us transcend. अगर किसी को ये नहीं समझ आती तो आई कैन गो टू सराइकी एज वेल. अगर सराइकी में समझना चाहो तो मैं वो दसण को भी तैयार हूं. ठीक है. इंपॉर्टेंट थिंग इज दैट तुम लोगों को समझ जाए. सबसे पहली चीज जो है, आपकी टोन ऐसी होनी चाहिए जो जज को बुरी ना लगे. सबसे पहले मैंने आपको बताया कि अदालत के अंदर, मूट कोर्ट के अंदर वर्ड सर नहीं होता. यू हैव टू बी स्ट्रिक्ट टू योर ऑनर. मैंने आपको बताया देयर आर कॉनोटेशंस फॉर द जजेस, हाउ यू हैव टू आस्क देम. सेकंड थिंग, द टोन जिस पे मैं बात कर रहा था, आपकी टोन क्रिस्प होनी चाहिए, क्लियर होनी चाहिए, वाइब्रेंट होनी चाहिए. उसमें पता चले कि ये स्टूडेंट, ये काउंसिल लॉ के किन फंडामेंटल प्रेमाइजेस को आंसर कर रहा है और किस जगह को टच कर रहा है. और आप अपने ख्यालात में बिल्कुल क्लियर होने चाहिए. कुछ भी आपके अल्फाज के अंदर मरमरिंग नहीं होनी चाहिए. ऐसा ना हो कि आप मुंह के अंदर बोल रहे हो और जजेस को ये कहना पड़े कि आई एम नॉट एबल टू अंडरस्टैंड, प्लीज कैन यू रिपीट इट, तो दिस इज नॉट अ गुड एस्पेक्ट। आपको क्लियर होना चाहिए। और आप देखो, अब ये क्लैरिटी आती कैसे है, मैं तुम लोगों को ये बताता हूँ। देखो, सबसे पहली तो है स्ट्रॉन्ग नॉलेज, पहली चीज। दूसरी चीज जो है कि आप लोगों का माइंड, आप लोगों की व्हाट यू आर स्पीकिंग उसके साथ बिल्कुल पैरेलल चल रहा हो, कि मैं ये बोलना चाह रहा हूं या मैं ये बोलना चाह रही हूं और मैं वही बोलूं। ऐसा ना हो कि मैं स्लिप ऑफ टंग में कोई ऐसी बात करूं जिस पे जज मुझे पकड़ ले। और ऐसा होता है, मैंने नेशनल मूड कॉम्पिटिशन्स को जज करते हुए भी ऐसा, बहुत कैपेबल स्टूडेंट्स थे, जो बहुत कैपेबल काउंसिल्स थे, जो बहुत अच्छी प्रिपरेशन के साथ आ रहे थे, उनका प्रॉब्लम ये अक्सर हो जाता था कि स्लिप ऑफ टंग में या ओवर कॉन्फिडेंस में, प्लीज ये ओवर कॉन्फिडेंस जो है इसको नहीं साथ लेके आना, इसको अपने कोर्ट के पॉकेट में रख के कोर्ट के बाहर छोड़ के आना है। इसको अगर अंदर लेके आओगे, इट विल गेट यू ऑन अ फिक्स, क्योंकि जज इज एट अ पीक ऑफ कॉन्फिडेंस। मैं आप लोगों को बता रहा हूं कि जो जज होता है, ही इज ऑलवेज सिटिंग इन अ सर्टेन अप डायरेक्शन, ठीक है, वो थोड़ा सा ऊपर बैठा हुआ होता है आप लोगों से, और ऊपर बैठने वाले का कॉन्फिडेंस वैसे ही बूस्टेड होता है। तो डू नॉट थिंक कि जज को कुछ आता नहीं है, जज को कुछ भी नहीं आता तो वो जज है, क्योंकि उसने डायरेक्शन तय करनी है। ही इज द टॉर्च बियरर ऑफ द प्रोसीडिंग, उसने डायरेक्शन तय करनी है। तो कभी भी ओवर कॉन्फिडेंट नहीं होना, अपनी टोन को एग्रेसिव नहीं बनाना। अगर जज, देखो मैं क्या करता था नॉर्मली, जब मैं ये देखता था ना अमार के कि ये स्टूडेंट या ये काउंसिल ओवर हो रहा है और ये सोच रहा है कि जो मुझे आता है दिस इज द एंड, मैं ये समझता हूं कि देयर इज नो एंड टू द लॉ, देयर इज नो एंड टू अ लीगल स्टडी। तो मैं क्या करता था कि मैं उस कॉन्फिडेंस को वहां ब्रेक करता था 2 या 3 क्वेश्चन से। और बिलीव मी, मैंने ऐसे काउंसिल्स भी देखे अपने कैरियर में जिनका कॉन्फिडेंस उसी वक्त प्लमेट कर जाता था। और ऐसे भी कॉन्फिडेंट कॉन्फिडेंट लोग थे जो ओवर कॉन्फिडेंट तो नहीं थे, लेकिन वो इतने कॉन्फिडेंट थे कि शहीर इज अ गुड एग्जांपल, आतिफ इज अ गुड एग्जांपल, ठीक है। ये लोग जो हैं देवर कॉन्फिडेंट, इन लोगों को पता था, मतलब मैं अब जब मैं जज था मैं उस वक्त की बात कर रहा हूँ, जब मेरा टाइम था तो उस वक्त भी हम लोगों में थे। खैर, अब बात यह है कि मैं अपनी अपीयरेंसेस में कभी भी ओवर कॉन्फिडेंट नहीं होता था। मैं ख्याल रखता था कि मैंने जज को असिस्ट करना है, मैंने जज को डिक्टेट नहीं करना। प्लीज डू नॉट डिक्टेट समथिंग टू द जज, वो आप लोगों को एक गलत एज की तरफ लेके जाएगी। थर्डली, अगर आपसे जज कोई क्वेश्चन पूछता है तो आपने कैसे आंसर करना है, देर आर 3 एस्पेक्ट्स। सबसे पहले तो आप ये कह दें कि जी द काउंसिल विल असिस्ट दिस ऑनरेबल कोर्ट इन अ लेटर प्रोसीडिंग, दिस इज वन थिंग, or later pleadings, or the co-counsel will assist the court in this very question. Second क्या चीज है, जो आप दूसरी बात ले सकते हैं, दूसरी बात आप ये ले सकते हैं कि जी you have to start like your excellency or your honor, as I have already mentioned, the aspect of this very questions are related to my second pleading, and what I would like to assist, what the counsel, I'm sorry, do not use the word I. Do not use personal pronouns. Use the counsel. The counsel would like to assist in this and this manner. So this is the good, and this is the appropriate, and this is the suggested manner. The third is that you apparently overtly give a denial. Your Excellency, the counsel is unable to assist the court in this very question. So this is the safe end. Please keep yourself on a safe end if you are not knowing something. There is no compulsion for you to answer every single question that has been asked by the judge. So these are a few things that I would like to mention. And as far as the oral proceedings are concerned, you have to be composed. I already said that. Ji, please.
Sir, Shahid bhai ka ek question hai. Sir, do kindly make clear if reading from a memorial sends a bad impression during an oral pleading.
Well, Shahid, another good question. अमार सी, होता ये है कि देखो, मतलब अगर मैं जज के सामने अपीयर हो रहा हूं और मैं रीडिंग कर रहा हूं, तो उसमें मेरी कुव्वत गोयाई कहाँ है? देखो ना, कुव्वत गोयाई तो वो है कि मुझे पता हो कि यस ये एस्पेक्ट्स हैं। और अब चलो, क्योंकि शहीर ने ये क्वेश्चन कर लिया, मैं आपको बता देता हूँ इसकी प्रैक्टिस कैसे होगी। जब आप अपना मेमोरियल बना के सबमिट कर देंगे तो जो आपके अपने मेमोरियल की कॉपी है उससे आप अपने नोट्स लेंगे, और वो नोट्स का एक पेज जो मैं भी करता था, आतिफ भी मेरे साथ किया करता था, और ये हम सब लोग किया करते थे। उससे क्या होता है, एक्सक्यूज मी, जस्ट लेट मी रिप्लाई। अच्छा, ओके, आई एम सॉरी। जो मैंने देखा कि जो हमने भी किया और हमारे जूनियर्स ने भी किया, और दिस इज अ गुड एस्पेक्ट। फॉर इंस्टेंस, शहीर भी ऐसा ही करता था। आई स्टिल रिमेंबर शाहजेब वाज गुड मूटर। कुछ और लोग थे, मुझे अब उनके नाम आई कुड नॉट रिकॉल। प्लीज, आई एम सॉरी टू यू पीपल इफ यू आर हियरिंग। ऐसा ना समझना कि देयर वर मेनी जेम्स इन दैट कंपटीशन। तो अब ये कुछ नाम मुझे याद हैं। अब बात ये है कि ये लोग क्या करते थे कि ये लोग एक पेज पे लिख के आते थे, और मैं खुद भी ऐसा करता था। जब आप एक पेज पे पॉइंट्स लिख के आते हैं और अपनी प्रैक्टिस में, फॉर इंस्टेंस अमार, आई एंड यू आर अ मेंबर, आई एंड यू आर अपीयरिंग इन सर्टेन मूड कोर्ट कंपटीशन, व्हाट वी विल डू, I will help you in memorizing your pleadings, your oral pleadings, and you will aid me in memorizing the my aspects of the pleadings. तो ये होगा क्या कि जब मैं अपनी pleadings तैयार करने में आपको सुना रहा हूँगा, तो मैं एक सिंपली पेज ले रहा हूँगा, कोई भी वो पेज हो सकता है, उस पेज की बेसिस पे मैंने अपनी आर्गुमेंट्स, मेन आर्गुमेंट्स याद किए हुए हैं। इससे दो फायदे होते हैं। पहला तो ये कि आप रीडिंग में टाइम वेस्ट करते हैं। दूसरा, आप जज के साथ एक कांटेक्ट नहीं मेंटेन कर पाते, जो एक नेगेटिव ऑरा होता है ऑफ अ काउंसिल। तीसरी बात, जैसा कि शहीर ने कहा, बिल्कुल इसका जी बैड एक्सप्रेशन जाता है। तीसरी बात यह है कि जब आप देखो, जो आपका मेमोरियल है उसमें आपकी सबमिशंस जज पढ़ चुका है, ही इज नोइंग। Please understand that he has read. Now he wants you to assist him more. He wants you to give a crisp and clear analysis of what you have written in your memorial. So अब होगा क्या कि जज क्या करेगा, बेसिकली वो आप लोगों को देखेगा कि जी इसने अपने पॉइंट्स दिए, तो ये चीज अल्टीमेटली उसको रूम देगी कुछ क्वेश्चंस पूछने में। और अगर आपकी स्ट्रॉन्ग कमांड है और आप जजेस के क्वेश्चंस को टू सम एक्सटेंट, मैं ये नहीं कहता 100%, 50% और 70% एड्रेस कर देते हैं, तो इट इज अ पॉइंट ऑफ योर कॉन्फिडेंस, एंड दिस विल गिव योर marks a very good boost as well. So please do not read the memorial. Memorize the memorial, memorize important aspects of the memorial, and memorize the legislations. अमार, एक चीज और, लास्ट थिंग, शहीर होता क्या है कि स्टूडेंट्स क्या करते हैं कि जब अपनी रिसर्च को वो लोग मेमोरियल की फॉर्म में प्रेजेंट करते हैं, तो उससे पहले के कुछ दिनों में वो अपनी जजमेंट्स का बैकग्राउंड भी नहीं पढ़ते और उसके फैक्ट्स को भी नहीं पढ़ते। सिर्फ जजमेंट की एक लाइन जो उन्होंने मेमोरियल में रेफर की है, उसी को पढ़ के तोते की तरह जज के सामने बोल देते हैं। अगर मैंने ये पूछा कौंसिल, व्हाट वर द फैक्ट्स ऑफ दैट केस, अब आगे कौंसिल साहब सुमन बुकमन होके खड़े हैं, तो व्हाट डू यू एक्सपेक्ट कि ये क्या मेरे लिए एक अच्छा इंप्रेशन जाएगा? कभी भी नहीं। तो जो अथॉरिटी, जो प्रेसिडेंट आप मेंशन कर रहे हैं, आपको उसके ऊपर कमांड होनी चाहिए, आपको उसका बैकग्राउंड पता होना चाहिए, किस जज ने इस जजमेंट को ऑथर किया है, ये किस कोर्ट की जजमेंट है, और इस जजमेंट के बाद क्या कोई एडवर्स जजमेंट या सुपरसीडिंग इफेक्ट इस जजमेंट के ऊपर लार्जर बेंच से तो नहीं आया। दीज आर द थिंग्स दैट आर पर्टिनेंट टू बी नोन बाय द काउंसिल। जी अमर, प्लीज।
ठीक, ओके सर, लास्ट क्वेश्चन, उसके बाद we'll go for the conclusion of our today's webinar. Sir, how important, because मैंने ये चीज़, I learned it in a hard manner कि once in Lahore High Court I was there and मैं कोट पहनना भूल गया था, तो फिर जज साहब ने मुझे कोर्ट एथिक्स सिखाई थी वहाँ सारी कोर्ट में खड़े होके। तो सर, आपकी अपीयरेंस कितनी मैटर कर रही होती है इन सब
बहुत ज्यादा।
इश्यू?
देखो मेरी बात सुनो, अगर मुझे कहोगे ना तो मैं कहूंगा अपीयरेंस इज 30%। मतलब 70% इज योर एड्रेसल, फॉर मी 30% इज द अपीयरेंस, फॉर मी 30%। मतलब कि अब एक काउंसिल साहब के, आप देखो होता है, मैं मूट कोर्ट की बात ही नहीं कर रहा, लेकिन मूट कोर्ट आपको इनेबल करेगी इस चीज पे, आपके कॉन्फिडेंस में। अब एक काउंसिल साहब के डिस्ट्रिक्ट कोर्ट में खड़े होके एक सिविल जज के सामने शिवरिंग हो रही है, हाथ कांप रहे हैं, तो मतलब वो वकील साहब क्या रिलीफ लेंगे, मतलब वो जज को क्या कहेंगे, मतलब किस प्लेट में रख रिलीफ दे दें, कांपते हाथों के साथ? तो कांपते हाथों के साथ तो कोई रिलीफ नहीं मिलता। और होता ये है कि अच्छा मैं आपको बताता हूँ कि जब आप कॉन्फिडेंस अपना लूज करते हैं ना, तो फिर आप, मैंने आपको बात बताई थी ना पैरेललिज्म की, वो पैरेललिज्म नहीं मेंटेन रह सकता आपकी थॉट्स और व्हाट यू आर गोइंग टू ऑरेट उसके अंदर। तो और जो आपकी वेल अपीयरेंस होती है, जो आपका अच्छा सूट होता है, अच्छा कंपोजर होता है, जो आप की नाइस प्रेजेंटेशन होती है, यू कैन कॉल इट फिजिकल अपीयरेंस एज वेल। मतलब अब मेरे सामने अगर कोई कौंसिल साहब आ रहे हैं जिनके बाल प्रॉपरली मेंटेन्ड नहीं है, ठीक है, या जिनकी बियर्ड शेव्ड नहीं है, जिसकी मुस्टैच ट्रिम्ड नहीं है, तो मेरे लिए, या मेरे मेरे सामने कोई फीमेल कौंसिल आ रही हैं, शी इफ शी हैज नॉट मेंटेन्ड हरसेल्फ प्रॉपरली, देखो देयर इज अ कंपोजर। मैंने अपने सामने कोर्ट्स में फीमेल कौंसिल्स को भी जजेस को कहते सुना है। फीमेल जज ने एक दफा मेरे सामने एक कौंसिल को ये कहा कि इज दिस एन अप्रोप्रिएट अपीयरेंस इन द कोर्ट ऑफ लॉ। सिंपली था क्या कि उनका जो दुपट्टा था दैट वाज नॉट फॉर्मल, तो उन्होंने कहा प्लीज अडॉप्ट फॉर्मलिज्म। तो फॉर्मलिज्म इज द की। ये बोथ द जेंडर्स, बोथ की सेम बात है कि यू हैव टू बी कंपोज्ड, यू हैव टू बी डिसिप्लिन्ड, यू हैव टू बी, यू हैव टू बी लाइक, आपने देखो प्रेजेंट करना है खुद को, तो कैसी प्रेजेंटेशन होनी चाहिए। और प्रेजेंटेशन के अलग मार्क्स होते हैं, मूड्स में भी और कोर्ट्स में भी। ऑल्दो वो मार्क्स आपको लिखे हुए नहीं मिलते, लेकिन जज के सामने आपकी एक स्टैंडिंग डेवलप जरूर होती है। एक मुस्कुराहट के साथ आपने जज के सामने अपीयर होना है। मतलब अमार जस्ट इमेजिन कि एक जज है, उसके सामने एक कौंसिल अपीयर हो रहा है जिसको नींद आई हुई है, मतलब कि वो ऊँग रहा है, उसकी अंगड़ाइयां ले रहा है, मतलब जज अब उसको क्या कहेगा कि भाई तुम्हें मैं एक दिन देता हूँ, प्लीज जाके थोड़ा रेस्ट करो, कल आना। ऐसा नहीं होता, वो एडवर्स ऑर्डर्स लिखेगा। तो what you have to make sure that you are having a good composure, you are having a good personality. Personal aroma is really important in the court of law. जी अमर।
Thank you so much, sir. I hope all the questions, even for the beginners and for the mooters, all the questions are understandable now. Everything is clear. Thank you to you, sir, for giving us time, for giving the council the
प्लेजर
time.
अमर, प्लेजर।
Any closing remarks, and then we'll go for the conclusion, sir.
अमर, क्लोजिंग रिमार्क्स की हद तक सिर्फ इतना ही है कि प्लीज अपने इस टाइम को गनीमत जानो। आपको लोग कहेंगे, प्लीज मैं आपको क्लियर बता रहा हूं अमर, आपको लोग कहेंगे कि जो यहाँ का लॉ है और वहां का लॉ है वो मुख्तलिफ है। तो मैं अक्सर, वी थ्री सिबलिंग्स आर इन लॉ, तो मैं अक्सर हंसता हूँ अपने सिबलिंग्स के साथ भी, क्या ये लॉ दुनिया का लॉ है और वो लॉ आलम अरवाह का लॉ है? तो बिल्कुल ऐसा नहीं है। लॉ यही है, प्रोसीजर यही है, उसके ऊपर कुछ अमेंडमेंट्स, जुडिशियल अमेंडमेंट्स बाद में आई होंगी, लेकिन अगर आपने सब्सटेंटिव और प्रोसीजरल लॉ पे अपनी स्टडीज के दौरान ग्रिप नहीं डेवलप की, यू पीपल विल नॉट बी एबल टू अपीयर इन द कोर्ट ऑफ लॉ, और ये तुम्हारी प्रैक्टिस के 3 से 4 साल बाद में जाया करेगा। तो आज के वक्त को गनीमत जानो और इस वक्त में खुद को पॉलिश करो, अपनी एडवोकेसी स्किल्स को भी और अपनी लर्निंग स्किल्स को भी। जजमेंट्स पढ़ो ज्यादा से ज्यादा और कॉन्स्टिट्यूशन की कमेंट्रीज पढ़ो, सो दैट कि आप लोगों की नॉलेज बेस स्ट्रांग हो। जी हमारा
Thank you once again, sir. Thank you so much. I hope कि ये जो हमारा webinar है, it is enough for the mooters to prepare for the upcoming moot competition, and best of luck to all of them. Once again, thank you, sir Huzaifa. Thank you for your time. Thank you, sir.
टेक केयर, थैंक यू, अल्लाह हाफिज।
Allah Hafiz, sir.